It's time for one of my favorite activities here at the Four Boxes Diner, in addition to drinking coffee, of course. Busting anti-gun myths. Now, I want to tackle today one of the most persistent myths out there. I'm talking about the argument by the anti-gunners that the Second Amendment does not protect an individual right to keep and bear arms. Now, I devoted an entire video to what the Second Amendment actually says and how to understand it in historical context. But in the comments to that video, right, some people were saying, hey, Mark, as a constitutional scholar, don't you know how to read? After all, the first part of the Second Amendment talks about a quote-unquote well-regulated militia. So how can the founders actually have been talking about individual rights in the context of the Second Amendment given that prefatory clause? Well, you ask, so I'm going to answer. When we get back, we're going to dive into what the well-regulated militia clause actually means. Hey folks, I'm Mark and welcome to the Four Boxes Diner. Okay, here's the full text of the Second Amendment to the Constitution. Quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Close quote. Now, if you want a full breakdown of that entire language, check out my video, What the Second Amendment Actually Says. But for this episode, I just want to focus on the first part of the Second Amendment. That's the part that the anti-gunners make the biggest stink about, okay? You see, they argue that look at the first part of the Second Amendment, Mark. See, it proves our point. The founders only meant that military organizations like the National Guard or the Army or someone else should have arms because it refers to a well-regulated militia. Okay? Here's the thing. The United States, let me start from the beginning. The United States Supreme Court has already said unequivocally, this is not my view, it is my view, but this is not what I'm relying on for this particular point. The United States Supreme Court in the Heller case in 2008 wrote like a 150-page opinion with hundreds if not thousands of footnotes that said that the Second Amendment protects an individual right. Okay? That right is, quote, unconnected with service in the militia, close quote. That's not Mark, that's what the U.S. Supreme Court said. Okay? Now, from a constitutional law perspective, there's no debate that the Second Amendment protects an individual right. Don't believe me? Well, there's also a second huge Second Amendment case before the Supreme Court right now. It's called the New York State Rifle and Pistol Association versus Bruin, or NYSERPA versus Bruin. Now, in that case, all the parties agreed that the Second Amendment, and by the way, when I say all the parties agreed, I'm talking about even the state of New York. New York is not exactly a great gun community. I think we'd agree on that, right? Okay. In that case, again, all the parties, including the state of New York, who's the defendant, agreed that the Second Amendment protects an individual right. All right? So that should really be the end of the conversation, shouldn't it? But since the anti-gunners will not let this issue go, right? I see it in the comments all the time on this channel. I want to run through the reasons why their arguments about why the phrase a well-regulated militia simply do not add up. First things first, the part of the Second Amendment that mentions a well-regulated militia is known as the Prefatory clause. The Prefatory clause. The rest of the amendment, that's the part that talks about the right to keep and bear arms, is known as the Operative clause. The key word here is the word operative. You see, the Operative clause tells us what the actual protected right is. Okay? The Operative clause says plainly that the right belongs to the people, not just to the National Guard, to the militia, to the Army. Now pay attention again. The Prefatory clause does not change the meaning of the Operative clause. Instead, the Prefatory clause, referring to the well-regulated militia, does only one thing. That is, it states and, I repeat, an important reason, not the only, but an important reason for the Operative clause to exist. And the Operative clause facilitates the realization of, or the creation of, if you will, the Prefatory clause, namely that the right of the people to bear arms helps to realize a well-regulated militia by having armed people to draw a militia from. Okay? Now, again, this is not Mark, although it is Mark, but it's not Mark exclusively, because the United States Supreme Court explained all of this in excruciating historical and grammatical and textual detail in the landmark 2008 case of District of Columbia versus Heller. You see, the Supreme Court's ruling there said, quote, the amendment's prefatory clause announces a purpose, again, a reason for, but does not limit or expand the scope of the second part, the operative clause. Again, that's the Supreme Court drawing the distinction between a well-regulated militia, being the prefatory clause, explaining a reason for the existence, of the operative clause, which is the thing that gives you the right, or in this case, recognizes a pre-existing right, of the right of the people to keep and bear arms. Now you may be wondering, Mark, is this the best you've got? Diagramming sentences like we're in middle school? How boring, this is crazy talk. Now, you might even be saying that the Second Amendment talks about a well-regulated militia, and that somehow that's the government does the regulating. So clearly the founders were talking about a government-run military outfit of some sort, whether it be the National Guard or something similar today, right? That's what the argument is. Nope. Again, that's wrong again. Let me explain. We may think of government regulations today when we hear the term well-regulated, because in the 21st century, well-regulated to us means things like the Alphabet City group of government agencies that we're all familiar with. That could be the FEC, which is the Federal Elections Commission, regulating elections. It could be the SEC, regulating the security markets and Wall Street. But back in 1791, you see, when the Second Amendment was written, again, 1791, the phrase well-regulated did not mean administrative agencies like the Environmental Protection Agency. That's not what it was referring to. The phrase well-regulated in 1791, when the words were written in the Constitution, meant to be effective, to be competent, to work, not to oversee or regulate as a government agency. It simply meant, again, to be effective, competent, or simply to work, okay? Now, if you listen to this dictionary, I want to give you a dictionary definition of the word regulated from 1828. This is the Webster's 1828 American Dictionary of the English language. Webster says that the word regulated means, quote, adjusted by rule, method, or forms, put in good order, subjected to rules or restrictions, close quote. So what made a militia well-regulated during the founding period? Basic things. Months after the Second Amendment was ratified, keep in mind, President George Washington, our first President George Washington, signed the Militia Act of 1792. That law said that you needed to be between 18 and 45 years of age to join a militia. In other words, a well-regulated militia doesn't have people too young or too old to serve in it. It consists of able-bodied people who can traverse over long distances, run, and fight. The Militia Act also spelled out what supplies militia members needed. Anyone who joined the militia, the law said, must, quote, provide himself with a good musket or firelock, a sufficient bayonet and belt, 2 spare flints, and a knapsack, a pouch with a box therein to contain not less than 24 cartridges, close quote. Did you catch that? Each militia member had to provide his own firearm. But think about it. How could someone bring his own firearm for militia services if the citizens didn't have them, right? If the citizens did not have the right to keep and bear arms, how would they have the guns to serve in the militia? Why would Congress have written a law in this way? Again, think about this again. If the founders intended the Second Amendment to mean what the anti-gunners argue, and what they argue, of course, is there is no individual right to keep and bear arms, then there would be no American at the time experienced enough or with the requisite supplies, the musket and cartridges, among other things, to make up the militia that the Founding Fathers wanted to make sure were never disbanded and were always well-regulated or effective. So we've talked about the term well-regulated. Now let's look at the word militia at the time of 1791. Did the founders have in mind, when they wrote the Second Amendment, a military operation run by the government? Nope, that's not what it was. Their idea of a militia was one run by the people. In 1774, George Washington and George Mason founded the Fairfax Independent Militia Company, okay? This militia was independent and volunteer. It took no orders from the royal governor. More to the point, look at how the founders talked about the Second Amendment and the militia around the time of its ratification in 1791. During the Virginia ratifying convention, our founding father, George Mason, said, quote, "Who are the militia? They consist of the whole people, except for a few public officers." Close quote. That was George Mason, a founding father. And during the Massachusetts ratifying convention of the U.S. Constitution, Samuel Adams declared that the Constitution should, quote, "never be construed to authorize Congress to prevent the people of the United States who are peaceable citizens from keeping their own arms." Close quote. Or listen to the man himself who wrote the Bill of Rights, James Madison. In Federalist Papers, he specifically talked about this in Federalist Paper 46. That's 46. Madison said that a militia of ordinary citizens would resist government tyranny. He asked his readers to consider an unlikely scenario. Say a tyrannical standing army emerged that was entirely at the devotion of a federal government. Don't worry, Madison said, don't worry. Opposing that standing army would be, quote, "a militia amounting to nearly 500,000 citizens with arms in their hands, officered by men chosen from among themselves, fighting for their common liberties," close quote. That was what James Madison, the author of the Bill of Rights, said. Now, James Madison also said other things. Madison also said that Americans possessed an advantage, quote, "over the people of almost every other nation," close quote. And what exactly was that advantage? What made Americans special? It was the advantage of being armed. Madison wrote that. You see, governments in Europe were afraid to trust the people with arms. Okay? Not the United States, though. Well, of course, today's anti-gunners who love government, a lot of them do, I don't think they trust the people with arms. They would trust the government with arms. That's not my view, though. In some ways, the most obvious point that the Second Amendment protects an individual right, notwithstanding its well-regulated militia clause, is where do you find the Second Amendment? Okay? It's found in the Bill of Rights. The first 10 amendments to the Constitution are the Bill of Rights. Now, who has rights? Well, the only things or people with rights are ready, human beings, individuals. Okay? You see, state governments, federal governments, they don't have rights. Government doesn't have any rights. What government has are powers or authorities. People, individuals, have rights. Now, if you look at the Bill of Rights, guess what? The Second Amendment is in the Bill of Rights. Discussions about powers involving the federal government appear in Article 1 of the Constitution, not in the Bill of Rights. Again, if you look at the Bill of Rights, a reference to the people appears not only in the Second Amendment, but it appears in the Fourth Amendment, the Ninth Amendment, and the 10th Amendment. And this has always been understood to be individuals as part of the people, because the people are individuals and not government. So let's wrap up. The anti-gun crowd stubbornly sticks by the argument that the Second Amendment does not protect an individual right to bear arms. They say that it's about militias or the National Guard, and that's it, not an individual right. Now, of course, this is simply nonsense, but a lot of people believe this, and I know this because I see it in the comments on my channel here. Okay? So when you hear about this argument, I want you to remember there's five reasons at least, why this argument that the phrase "a well-regulated militia" somehow turns the Second Amendment into something other than an individual right. First, the United States Supreme Court has expressly said that the Second Amendment protects an individual right to keep and bear arms. And even the anti-gun lawyers before the Supreme Court right now in the NYSERPA versus Bruin case don't seem to be challenging the Heller decision or the precedent that found that the Second Amendment is all about individual rights and not state militias or the National Guard. Yet we know that the anti-gunners stick with this talking point in public debate and in op-eds because they think they can fool a lot of people by not mentioning the fact that the Supreme Court has already resolved this issue clearly. Second, the prefatory clause in the Second Amendment that mentions a well-regulated militia doesn't limit the individual right expressed in the operative clause. Again, the Supreme Court has said this explicitly. Keep in mind that the First and the Fourth Amendments, which also refer to the right of the people, also have several various clauses, but no way does anyone argue that one clause in those amendments somehow nullifies or eliminates the other clauses. Now, the third point to keep in mind is that when the founders wrote the words "well-regulated," they were not referring to a militia regulated by the government. What they meant was that well-regulated meant effective or competent. Okay? And fourth, the founders' idea that militia was one run by the people. The way they spoke about militias and organized them shows this. Okay, look at the Militia Act of 1792, for example. And as founding father James Madison, who wrote the Bill of Rights, what did Madison say? Madison said that Americans enjoyed an advantage over the people of other countries. Specifically, quote, the advantage of being armed, close quote. That was James Madison. And last but not least, keep in mind, where do we find the Second Amendment in the Constitution? We do not find it in a part of the Constitution dealing with governmental powers. We find it in the Bill of Rights, the first 10 amendments to the Constitution, which are designed to protect and codify certain individual rights, including the right to keep and bear arms, in the Constitution. If this was talking about some sort of governmental power, it would appear either in Article 1 of the Constitution, which this does not, or in some other reference. Because remember, you and I have rights as people. Governments have powers and authority. They're not the same. And you would not put discussions of governmental power in a Bill of Rights, because frankly, it really would not fit. Okay, well, I hope you learned something today, and thanks again for joining me here at the Four Boxes Diner, where we serve fresh, hot Second Amendment news and analysis. And if you like what you heard, please subscribe and help spread the word. I really appreciate it. And again, if you want to dig into the full text of the Second Amendment, feel free to check out my video what the Second Amendment actually says. But either way, we'll see you again soon, hopefully, at the Four Boxes Diner.
Orders up. Table 2A.